Good morning, Your Honor.
Mr. Bennett.
Yes, good morning. Can you hear me, Judge?
Mr. Bennett, please log on to Judge Green's Zoom.
Judge Green?
Yes.
Okay.
Thank
I
you.
have it. I had the only Judge Oakley's Zoom ID that we got sent. What is Judge Green's?
I can hear you. It's 933-057-8570.
Okay, thank you, Your Honor. Have a great day.
You too, thank you.
Thanks. Bye-bye.
I'm sorry, hold on one second. Oh, did he? Mr. Bradley?
Hello?
Mr. Bradley, you're in the wrong courtroom.
I am?
Yes,
What courtroom am I supposed to be in?
you're supposed to be in Judge Green's Zoom.
Green. Is that court?
It's courtroom number 3, sir.
Okay, I'll go back and do it again.
Thank you, sir.
Thank you. Okay, bye.
Sir, with the beard and the green shirt, your name, please.
Blake Metzger.
Mr. Metzger, you are in the wrong courtroom. You should be in Judge Green's courtroom, okay?
Okay,
Thank you, sir.
no problem. Thank you.
Ms. Nelson, you had one job this morning. You're on. I'm coming right now. Give me one moment. This is 220599 SM. This is State of Michigan versus Tommy Joe Ford. May I have your appearances, please?
Your Honor, on behalf of Mr. Ford, with regard to the arraignment, we would waive formal reading and stand mute.
Ms.
Mr.
Medina,
Yes,
may I have your appearance, please, ma'am?
Crystal Marie Medina on behalf of Mr. Ford.
Thank you. Mr. Ford, state your name for the record.
Tommy Joe Ford.
And Mr. Ford, you're able to hear Ms. Medina?
Yes.
She's indicated that you're standing mute to the charges and waiving the reading of the formal charges in this matter.
Yes.
I'm sorry, Ms. Medina, I cut you off.
Oh, it's quite all right, Your Honor. We would just waive formal reading, stand mute. Thank you.
Thank you. Mr. Ford, you have an absolute right to be considered for pretrial release in this matter. There is a request from Sumter Township Police that seems to be in a little bit of conflict. They indicate the police department has no known reason to oppose a personal bond, but then request bond in the amount of $5,000, 10%. With the indication that you had a prior DV case and their pending charges. Ms. Medina, what say you to the bond recommendation, ma'am?
Your Honor, what I had seen was the fact that they were not opposed to a personal bond. So I don't know if I needed to look a little, that's what I had in terms of my paperwork, was that they were not opposed to a personal bond. That was the last thing I was aware of. I know that Mr. Ford indicates that he is gainfully employed. However, he is the support for his 3 children that he does have in common with the complainant. He's expected back at his employment, Original Soft Cloth Car Wash in Monroe, as soon as possible. Your Honor, my understanding is that he's not currently on probation or parole and that he could reside with his parents in Ypsilanti and have no contact with the complainant in this case.
Ms. Medina, I'm sure your paperwork looks just like mine towards the bottom. It does say requested bond amount of $5,000, 10%.
I see that now, Judge.
Okay.
I saw the first box and then I apologize. Still getting familiar with this paperwork.
No worries.
And so, Judge, I would ask that the court consider a personal bond since there is no reason to oppose apparently. And my client, again, has an alternate residence, understands he used to have no contact, has gainful employment. And that's what I would ask the court to consider, Your Honor.
Your Honor, Officer Tony, Sumter Township Police Department. On behalf of the police department, I don't believe we would oppose a personal bond, providing the no contact.
Thank you. Good to
You're
see you,
welcome.
sir.
Always a pleasure, Your Honor.
The court will set your bond at $5,000 personal, sir. You are to have no contact with the complainant, in this case, that being Cynthia Ford. You are not to return to 43054 Judd Road. I'm looking at his criminal history, Ms. Medina, and there is nothing there. That's the basis for the personal bond. The next step in these proceedings, sir, will be a pretrial on Tuesday, September 13th, 2022 at 8:40 a.m. That will be with Judge Oakley in courtroom number 2. That will be by Zoom. And again, you'll receive a copy of this notice from the police department before you leave, sir. It's the case number is 220599 SM. Next date will be the Zoom pretrial on September 13th, 2022 at 8:40 a.m. N2 with Judge Oakley. Anything else in this matter, Ms. Medina?
No, Your Honor, just accept my apology that when I'm looking at things electronically, I need to keep scrolling apparently. Keep scrolling.
I do
Anyway,
this. I do the
thank
same
you.
thing, ma'am. Thank you so
I
much.
like everything with paper and pen. I still wrote my lost words down. Thank you so much, Judge. And
Mr.
thank
Ford,
you,
have a good day.
You too.
Thank
Your
you.
Honor.
Thank you, Your Honor.
Sumter Township, before you go, would it be possible to send over to the arraignment email inbox an updated address for Mr. Ford for where he'll be staying?
Absolutely.
Thank you.
You're welcome.
So with that said, we're going to
You're good.
All right. Got all this computer savvy. I just graduated from a flip phone.
Oh, that's okay.
Thank you.
You're welcome.
They'll come on and start talking.
You're good.
Detective Carmona?
It's
Good morning. I'm here for Sheena Taylor.
Hold on, I'm sorry. That's better. What are you here for, sir?
Sheena Taylor.
We've already done that case. The trial is set for September the 27th at 11 a.m. here in courtroom number 1.
Perfect. Thank you. Have a good day.
You too, thank you. Mr. Fisher,
yes.
you are in the wrong courtroom. You should be in Judge Green's courtroom. Did the court officer log you on or did you log yourself on?
The court officer.
Okay, could you get there? Thank you, Michelle. Somebody will come get you in the right courtroom, sir.
Okay.
Thank you.
and I turned out in February to be able to appear, and that might have been. Nothing is coming up for him, but I do know he was being into custody, so I don't know where he is now.
Mr. Geisha,
Yes, yes, ma'am.
you're in the wrong courtroom, sir. You should be logged on to Judge Green's courtroom. You'll see me, but it's Judge Green's log on information.
Okay, I don't know if I have that. Let me look.
I'll give it to you if you have pencil and paper.
I can find one. Give me just 1 second, Your Honor.
Your attorney is logging in, so I'll let him know that you're on your way over.
Okay, go ahead.
It's 933
Okay,
057 8570.
okay, let me read that back to you. 933-057-8570.
Yes, sir.
Okay, thank you. I will
See you
log
in a
out and log
second.
back in.
Thank you. Mr. Scanlon? Good morning. Your client's logged on to the wrong courtroom. I've given him the correct Zoom information. He'll be here in just a moment.
Okay.
Thank you.
Your Honor, can I just put the break off of the prosecutor real quick, please?
Yes, sir.
Okay, I'm sorry, I misunderstood.
Were you able to verify where he is, ma'am?
No, he's not listed in the
Andy. Andy.
See if I can move him out just.
If you can't, Mr. Hadley, this is the last thing we have, and we could just close the breakout rooms.
I just attempted to move Mr. Fisher into the main room. I think he should be.
Oh, here he is. Thank you. This is 2205554 SM. This is State of Michigan versus Carlos Fisher. May I have your appearances, please?
Good morning, Your Honor. Equal PE 3923, and just for the record, the complainant Stacey Fisher is also on Zoom.
Good morning, Your Honor. Attorney Josh Hadley appearing on behalf of the defendant, Mr. Carlos Antonio Fisher. We waived our physical presence in court. We're prepared to proceed today, and at this time, I've had a chance to discuss this issue with the APA, and we would like to avail ourselves of the people's plea.
Mr. Fisher, state your name for the record, sir.
Carlos Antonio Fisher.
Thank you. Mr. Hadley, what would that plea?
Judge, if I may, is it okay if I go through?
Absolutely.
Okay, just because it is not our usual plea that we do, there were a couple more specific recommendations that we have for time here. So the plea is for Mr. Fisher to plead guilty under or to plead guilty as charged for domestic violence under the 769.4A statute. He would be put on probation for 12 months. He required to take the batter's counseling 26-week course. During his probationary period, we do request that if he reporting probation with no drugs or alcohol consumption during those 12 months, no possession or purchase of any firearms. Mr. Fisher currently does have several firearms that we are requesting that he relinquish to the police department for safekeeping during his probationary period. Myself and the complainant are going to be working, and Mr. Fisher will be working with the police department to ensure that those firearms are given to them once the court has signed the order, and then once the firearms are removed, Mr. Fisher can return to the residence. That no contact order will be amended to no assault and contact. And I believe I covered all of the aspects of it.
I concur.
Mr. Fisher, raise your right hand for me, sir. Do you swear affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may put your hand down. Sir, you were able to hear the terms of the plea that Ms. Moisizian just placed on the record?
Yes.
And you've had the opportunity to speak to Mr. Hadley regarding the charges against you and the plea that's being offered?
Yes.
And sir, you wish to tender a plea of guilty as charged to the sole count of domestic violence in this matter?
Yes.
You understand that if the court accepts your plea in this matter, you will not have a trial of any kind?
Yes.
You will not have the opportunity to present witnesses on your own behalf or see and cross-examine witnesses put forth by the prosecutor?
Yes.
And sir, you're entering this plea freely and voluntarily?
Yes.
You haven't been threatened in any way, promised anything to get you to plead guilty?
No.
Are you pleading guilty because you are in fact guilty?
I understand.
I said, are you pleading guilty because you are in fact guilty? Mr. Fisher, is it true that on July 30th, 2022, in the city of Romulus, you committed the act of domestic violence by making an assault and battery upon Stacy Fisher?
Yeah.
Mr. Hadley, would you like to inquire further of your client?
We're still satisfied, Your Honor.
Are the people satisfied?
Judge, just to confirm their relationship status, that they are married and do have a child in common.
Thank you. Mr. Fisher, were you able to hear that?
Sorry, Ms. Fisher's hand.
I'm going to get to her in just one moment. Mr. Fisher, is it accurate that you are either married to Ms. Fisher, you have a child in common?
Yes.
Ms. Fisher, your hand was up, ma'am. How may I help you?
I was just wondering if he is going to be able to buy a new gun?
No, ma'am, not during the pendency of his probation with this court.
Okay.
Anything else?
No.
Ma'am, are the people now satisfied?
Yes, Judge, and again, just to maybe confirm on the record, if Mr. Hadley wants to inquire into how many current weapons or firearms Mr. Fisher has that they will be handing over to the police department.
I would agree. I think it's probably best to make the record on that, Your Honor. Mr. Fisher, can you tell us how many firearms you have that you own that are in the house?
Let's see. 1, 2, 3, 4, and I believe it's 4.
Is there okay, that was my understanding when there was 4. I think that there may be some indication. Ms. Fisher, is there a 5th firearm that you've located in the house? Maybe we should ask your input on how many guns are there as well.
I found 5 so far. I found 5 firearms so far.
Okay.
Mr. Fisher, do you have any issue with this 5th firearm also being then taken into custody by the Romulus Police Department during the pendency of your probation?
No, but the one is one that's not, it's like a long range, but it's not registered. Yeah.
Understood, but it is a firearm for the purposes of your probation, so it's going to go into the custody of the Romulus Police Department. Just want to make sure we got that. So it's going to be 4. Your Honor, for the record, then it'll be 4 handguns and 1 long gun that will be taken into custody of the police department during the pendency of the probation.
Thank you.
And absolutely, thanks for giving us a moment to clarify that. I think it'll make Romulus Police Department's life a lot easier if we make that part of it clear.
Mr. Hadley, are you now satisfied?
Absolutely, Your Honor.
Mr. Fisher, the court will accept your plea of guilty as charged to the sole count in this matter, that being domestic violence. As previously agreed by and between the attorneys, you will be placed on 12 months probation. This is a deferred sentence pursuant to MCL 769.4A. In addition to being placed on probation, you are to complete a 26-week batterers counseling. You are not to purchase, possess, consume any alcoholic beverages or drug controlled substances in this case without prior approval of the court. You will submit to testing. You will submit to random testing as directed by the probation department. The 4 handguns and 1 long gun for a total of 5 firearms that are currently at the residence, that being 6112 Swan Lake Drive in the city of Romulus. Those handguns will be surrendered to the Romulus Police Department for the pendency of your probation with this court. You are not to purchase, assume ownership of, or otherwise take possession of any firearms during the pendency of your probation with this court. You may return to the Swan Lake residence once the guns have been, all the firearms have been surrendered to the police department for safekeeping, and resume residence at the Swan Lake address. The current no contact order in this matter will be amended to a no assaultive contact order. The court will additionally assess a fine of $500, $100 in costs, $75 crime victims fee, all oversight fees associated with the probation department, $50 mandatory state cost, and $20 fund fee. The probation department will be in contact with you at the phone number and email address you have previously provided and confirmed with the court to help set you up for the your probationary period, including going over the terms of your probation with you. Anything else in this matter on behalf of the people?
No, Judge, and people, myself will be in contact with Mr. Hadley to ensure Ms. Firearms are reviewed, that Mr. Fisher will be able to return to the residence. We will work on getting that taken care of.
I saw you, Mr. Fisher. Give me one moment. Anything else, Mr. Hadley?
No, Your Honor, just, and maybe depending on what Mr. Fisher's last issue is, maybe I'll, we'll hold a second to answer on that.
Your question or statement, Mr. Fisher?
Yeah, the drug testing, running out back to this time would be, the opposite that I'm wanting medication. What would they do about that?
They'll take a list of your medications with the probation department so that your screening will not be impacted by things that you're mandated to take by your provider.
Okay.
Okay, anything else, Mr. Fisher?
No, that's it.
Anything else, Ms.
And-
Fisher?
Yeah, in that case, Your Honor, we're satisfied, and we thank the court for their time, we thank, Ms. Bosan for her time as well, and, Mr. Fisher, I'll be in touch with you as soon as we find out about the consummation.
Thank you. Everyone have a good day. That concludes this court's docket for the morning. Thank you all for your patience Yes, Mr. Fisher?
I'm just trying to figure out, do I stay here? or
No.
do I-
You'll leave and they'll come get you logged. They'll get that computer logged off. Don't worry about it. Thank everyone so much again for your patience. Everyone have a wonderful day.
Thank you, Judge.
Thank you.
Judge, for the other matters, the one that's for KPS, I'm assuming the other two, I think we have.
It was Agrawal and Bradley. They are show cause.
And then Bullion.
Bullion was show cause as well.
Thank you.
Thank you, ma'am.
Bradley here.
Oh, I'm sorry. Nope, I said Bradley. That's correct. It was Agrawal. Bullion had failures to appear. Stevenson was a failure to appear. You were out here for that. Hines, McAuliffe, and Rhodes.
Great, thank you.
Thank you. Have a good day.
Take care.
Yes, please.
Did you take it down?
We're still streaming because I have 11 o'clocks coming.
That's right.
And Mr. Mihana is already here.
Hi, can you hear me?
Mr. Mihana,
Yes.
I have a wedding. If you give me 1 second. Are you here for Judge O'Leary's docket?
I thought we were in front of you today on a Michael McCarran.
McCarran's at 1 o'clock.
Right, but there was something I wanted to address and I was trying to get the prosecutor on.
If you can get, I don't know who the prosecutor is. If
I
you can
do.
Get them.
Yes,
Okay,
thank you so much.
thank you.
Thank you.
Good morning. Is it Sherry or Sherry? Sherry Clark. And Matthew Brady. Was there anyone joining us this morning? Another friend. I'm just. Thank you so much. Thank you for your patience. I had a little bit of that problem, but. Hold her done, come and take pictures of whatever else you want to do. You bring black hair. Oh, you do outside. You can bring pens and photos. You want to bring? Yes, okay. This is, we're gonna do it later on. My husband did the same thing. We didn't get rings when we got married, and we forgot until like the day before. Why are you back behind the gate? You can come in and take your stuff down, however you want to take it. And we will do this. I'll switch back to this in a second, but I think I'm tall enough to reach this, and I'm really not. So, Marianne, I'm telling you, I try to do things. I try to be creative with it. Okay. So, I'm gonna have you all come stand this way. Because, oh yeah, so we're sharing. So you all can grab the video. You want to. I think for the first couple of times I feel bad for people who, other than that, are we ready? We've gathered here today to celebrate the union of Sherry Lynn Clark and Matthew Scott Wade. Marriage is an honorable state and should not be entered into life. If anyone can show any reason why Sherry and Matthew should not be welcome and joined together, let them speak now or forever hold their peace. Sherry and Matthew. I also ask both of you that if either of you know any reason why you may not be welcome to join together in matrimony, you confess it now. For be assured that if any persons are not joined together lawfully, their marriage is not lawful. The marriage ceremony is a celebration of love and friendship. Those who are assembled here today believe the two of you in your commitment to each other. I congratulate you on your decision to bind your relationship in marriage and urge you to remember during difficult times the words that brought you here today. That of love, respect, and friendship. Sherry, will you take Matthew in marriage and do you promise to love, honor, and care for him in sickness and in health, forsaking all others, as long as you both show it? And will you take Sherry in marriage and do you promise to love, honor, and care for her in sickness and in health, forsaking all others, as long as you both show it? And repeat after me. I, Matthew, take you, Sherry, in marriage, to have and to hold from this day forward, for better, for worse, for richer, for poor, in sickness and in health, to love and to cherish, as long as we both shall live. Sherry, repeat after me. I, Sherry, take you, Matthew, in marriage, to have and to hold from this day forward, for better, for worse, for richer, for poor, in sickness and in health, to love and to cherish, as long as we both shall live. In token and pledge of the vow made between you, ring. Place the ring on her. Repeat after me, Matthew. In token and pledge of the vow made between us, with this ring I commit. For as much as Sherry and Matthew have consented together in matrimony, and have borne witness to this before this company, and by virtue of the authority vested in me by the state of Michigan, and now pronounce you legally and forever married, may your love grow and your commitment to each other never. With this blessing. Hey, courthouse. So we have paperwork to sign, and so two of you, yes, okay. Oh, Ms. Johnson's here. Mr. Mihana, were you trying to go into a breakout room with her?
Yeah, me, you, and her, maybe?
Ooh, not me, you and her.
Well, I've already talked to her.
Okay, give me a second. I have some paperwork to sign.
Thank you.
So what's the story of your love and grandchildren? It's. Are you ready for us? So is my husband. How long have you been here? He's oh, was that big stuff?
Yeah, we've heard of that. And even, I think like voting is stuff too.
Or is he with all that?
He's an electrician. Oh. That was the scheduling issue. Was it work?
Yeah.
Because they told me there was always certain times you could come in. And you pick in right now, we're the judge's conference. And so I'm covering schedule cases for other people. So we were trying to pitch you in between the domestic docket and the criminal docket.
Oh.
Whatever they policy we do what yes is.
Yeah.
I don't care, we'll fit it in somewhere, it's a quick ceremony. And people who are committed to each other for life and having it down. You brought your friend, look at her, she's smiling.
Yeah, my best friend and my parents are gone.
My whole life.
Yeah.
Our sister, your friend.
Yeah.
Oh, so where are you guys going now for lunch?
And then go over.
No, go like that.
Yeah. No, they're trying to.
Oh, see pictures. I took it down. So they can hear this, but there's kind of all put together. I made those for everybody who gets married here. Yes.
We made it online. Disney, shiny, black and white, some phone, and then. Oh, Marianne, you can't see it.
But you know it's
because
good.
So you guys know this is your property. And you're gonna mail back this other.
Do something a little bit more.
Thank you so much.
You're so welcome. Congratulations.
Thank you.
And they worked out too, because your husband works with us. We're all together.
Oh. Oh, Marianne. I love that part. So, that part's over. I'm taking this part down, Marianne, because we're done with Judge Green's, but we have Miss Johnson and Mr. Mihana, and I see the jail. I don't know why the jail's here.
Here is
Good afternoon, sir.
Good morning, Your Honor. How are you?
I'm good. It's still only morning. Oh, it's felt like quite the day.
Yeah, you still got an hour and 25 minutes, but it's
Gosh.
counting.
What are you here for, sir?
Okay, I got a Cameron's Fitts, Fitts. It's scheduled for Judge O'Leary in 29th, but they said he's
Yes,
covering for her. Okay.
I'm Judge O'Leary.
Oh, you Judge O'Leary.
I'm covering for Judge O'Leary today. Yes.
Oh, yeah, because it's like, I looked at the mid, and I haven't had my coffee yet, and it says Judge Cicerelli from Westland was the magistrate. Then it had you and JIS, but O'Leary on the paperwork. So I'm like,
Judge O'Leary is out today. She asked if I could cover her criminal docket. She only had 2 cases, so I'm waiting for Mr. Fitz' attorney to show up, Mr. Quinn. I have not seen him yet this morning, but I have attorneys here on my afternoon docket, and we'll find out why momentarily.
Excuse me. Good morning, y'all.
Good morning, Mr. Fitz. How
Pleasure
are
to
you,
meet
sir?
you. Okay. I'm very skilled in law. I worked for Randall Upshaw Law Firm for many years. Anyway, ma'am, this is an open and shut case.
Mr.
And
Fitz?
that guy's not my attorney. I
Mr.
fired
Fitz?
him, and yes, ma'am.
Okay, I'm going to stop you for 1 second because I don't see the prosecutor for Judge O'Leary's docket. And so because there's no prosecutor here yet, and because you have an attorney of record that's not here yet, I understand you say he's not your attorney, but for our purposes, they
I
are.
dismissed him under Strickland versus Washington.
Okay, but give me a moment because I have my own docket. My case is here, so if you sit tight, as soon as I see Judge O'Leary's prosecutor arrive, I'll get your case called so that Wayne County can get you on your way for the day, okay?
Okay, miss, may I say one thing?
Absolutely.
I'm totally disabled. Dr. Abraham. I heard this at Kroger's or Michigan and Maryland the day before this. I don't even stay at this address. Neither do my brother. This is my dad. My daddy been dead since September 23rd, 2011.
Mr.
He's
Fitz,
using my brother's dad's name.
Mr. Fitz, I'm going to stop you again because I have 2 attorneys. Give me 1 moment. I'm going to mute you for a moment. Wayne County will unmute you when I get ready to call your case.
thank you, ma'am.
Thank you.
Let us know.
Mr. Mihana and Ms. Johnson.
Good morning, Your Honor.
Good morning, Your Honor.
This is 210645 FY. This is the state of Michigan versus Michael McCarran. Mr. McCarran is here in custody right off of the courtroom. We are streaming live. This matter is being recorded. Is there some procedural matter we need to discuss? Do I need to have Mr. McCarran brought out?
Judge, I didn't know that he was there already. If you would like to bring him out, I suppose I have no objection. I can tell you, I'm here to discuss the issue of discovery and requesting an adjournment on his behalf because there's still outstanding discovery. So if you would like him to listen, Judge, I have no objection. I did see him at the jail yesterday. He knows I'm making this. So I was going to waive his presence because I had not known that he was there.
He is here. He's been here since about 8:20-ish. I saw them pull up.
Okay.
I am, because I've had not communication with him, because he's been here on other matters before, I know that if he is here and not in the courtroom, we're going to have a problem. So let's
Right.
I'm switching to my real courtroom and I will get, there we go. Okay. Let's fix this. I've switched to my real courtroom. I'll see if I can get the officers to get Mr. McCarran in, and
Yes,
we'll
please.
continue to wait for Judge O'Leary's docket.
Thank you.
My secretary, I don't think is on anymore. Hey, Mr. Mihana and the prosecutor, Ms. Johnson, are here. Is there somebody available that can bring Mr. McCarran out? We're going to resolve this matter, I think, before the 1 o'clock scheduled time. They're here on Zoom. The attorneys are here. Thank you. Okay, bye. Okay. Hi. Garcia is bringing Mr. McCarran out in just a moment. Yes. He's been on. I thought he was, no, he's on. I thought he was here for Judge O'Leary's doc. Oh, you want to take these with you? Oh, I thought you were leaving. Hey, Sunshine. How are you? I'm wonderful. How are you? You missed the wedding? You missed the wedding.
You had a wedding this morning?
Why wouldn't I have a wedding with everything else going on?
Did you know you were having a
I
wedding?
knew I was having a wedding and I fit it in between Judge Green's domestic and Judge O'Leary's criminal docket. And Mr. McCarron's attorney is here with the prosecutor. We're gonna call the case now unless you guys just want to wait till 1.
You're gonna call it, what are they gonna do?
I don't know. I'm just here for the ride. I'm guessing that we're not having the exam because Ms. Johnson is standing by somebody else's front door. 25th, is that where you are?
Yes, Judge, I am. I have an exam here at 11.
I might as well wait and see what's happening. We'll get rid of them.
Yeah, we're trying to. I already called Jamie. Jamie knows that I'm trying to get him out here. It has been quite the morning. I am so happy for them. Her dress was stunning. It was cream colored, spaghetti strap. It had a ruffle like this. It had a nice slit. So I recorded it. So I turned them so they could see themselves and not see me. But Mr. Mihana's talking through the ceremony. People are trying to get married and he's back there doing whatever he does. I'm sorry, courtroom 1 is always a little, I don't know what the nice word is. Irreverent, maybe is the word. Okay. Nope. I did the same thing, Mr. McCarron. I said, because it felt like it's been the morningest morning ever. This is 210645 FY. This is State of Michigan versus Michael David McCarron. May I have your appearances, please?
Good morning, Your Honor. Brittany Johnson on behalf of the people, P83513.
Good morning, Your Honor. Najad Mihana appearing on behalf of Mr. McCarron, P59371.
And Mr. McCarron, your name for the record.
Good morning, Your Honor. Michael David McCarron.
So, Mr. McCarron, I have the courtroom screen set so you are able to see Mr. Mihana and Ms. Johnson. Mr. Mihana is not able to see you. I don't know that there's any reason why he would need to see you. Hold on.
I saw him last night, Judge.
Okay. I was trying to get it over there, but we had an exam scheduled for, in-person exam scheduled for 1 o'clock this morning. Mr. Mihana joined us at about 10:20 this morning and was able to get Ms. Johnson on. Based on that, I'm guessing that there's some procedural issue that has arisen. Ms. Johnson?
Judge, it is actually my request. It is not Ms. Johnson. Ms. Johnson was just kind enough to come on Zoom to allow me to make this request. So Judge, as the court is aware, I am attorney number 3 on this case, although the case seems a little old, it's not necessarily old in terms of since I've been on this case. The last time that we were at the court building, it was for an exam. I think it was in July, and I had requested an adjournment for some more discovery. I can tell you that Ms. Johnson has been forthcoming. She gave me some extra discovery that I did not have, nor did the prior attorneys have. But I think there's still some more outstanding discovery. I don't know if the best way to proceed is to file a discovery motion and have the court actually give us a ruling on what I am requesting. I think that might be the proper way because we tried to address it between each other and I don't have that extra discovery. We do have the exam this afternoon. I am requesting respectfully an adjournment of that exam so I can address those discovery issues. This is not a tactic to delay this case. My client is the one who's locked up. So if anybody's prejudiced, it's my client, nobody else. Judge, the issue with this discovery, there's kid stalk videos. I have 2 kid stalk videos. One is of the complainant, one is of the sister of the complainant. It was brought to my attention by my client because my client was involved in other proceedings before with family court that there was a 3rd video done by another sibling. According to my client, he had a transcript. Now, my client had a lot of legal documents. As the court is aware, there's a homicide case in which the police raided the hotel room where my client was living. He had a lot of legal documents that were all in a box. I don't know where those are. I did ask respectfully from the prosecutor to have the officer in charge to see if they can get those for me. I don't have those. Yesterday in meeting with my client, there was some mention by a prior counsel that possibly maybe he and his investigator might have obtained some of those. I don't know. I have to ask the attorney. But some of the petitions as well, my client is still going through juvenile court. He has ordered some about a week ago. But regarding the skid stalk video, my client says he had it transcribed. It was left in the hotel. He obviously doesn't have it. According to him, and I haven't listened to it because I don't have it, prosecution doesn't have it, OIC doesn't have it. But allegedly, another sibling of the complainant tells the interviewer that it was not my client who committed these acts, but rather it was his other brother. Well, if that's the case, I would presume that that's exculpatory evidence that I need to be able to review. There's also information in the CPS report that she has, Ms. Johnson was kind enough to give me, that does make a mention that there was a kid stalk interview of the other brother, Brian Oakes. But of course, it doesn't make that mention of the issue of him making the allegation that it was his other brother, which, you know, if it is on the video, that brings more question as to why it's not in the CPS report. But also the information I have from my client, there is some mention of it in one of the CPS reports. I don't know if that's the original CPS report though, that it was the deceased, who is Jennifer, who is the mother of the complainant, who first made the allegations to CPS that it was her older son, Mikey, who committed the allegations against the complainant in this case. That was made to CPS on July the 1st. I don't have a copy of that report. In the report that was supplied to me by the prosecution since the last court hearing, there's just a one-line mention that the mother made these allegations. It doesn't have the date or anything. So I'm assuming there should be a separate report that discusses that. If that's the case, then I would think that's also exculpatory, and I would have the right to look at it to see what it says for cross-examination. I know my client wants some other pieces of evidence as well, but my main 2 things right now are those 2. There is an allegation of a call that was made by the complainant to my client while he was part of MDOC, in which he allegedly apologizes to my client for making up the lies about these allegations. I am trying to see if those are still recorded. How would I be able to obtain them? I don't know if they're still. I would like to look into that. But my 2 main things right now, Judge, are this kid stalk video of a sibling that I believe was interviewed on the same day as the complainant, in which he alleges that it was his other sibling who did this to him. And the CPS report regarding the allegations that mom was the first one who made these allegations to CPS, and it was after that the complainant comes forward and now says it's my client. So I think that is very relevant to my case. If it's the mom who first makes these allegations that it's her other sibling who did this, and suddenly we have the complainant now going to CPS and making the allegations, and now it's my client.
Okay, Mr. Mihana, before Ms. Johnson responds, I just want to be clear,
Yes.
because you said 4 things, but now you just said 2 things. So I want to be sure that we're all on the same page. You're requesting a copy of the Kids Talk video with the complainant's sibling that has
Yes.
not previously been provided to you.
Yes.
The copy of the CPS report, you said July 1st, you didn't say the year, but I'm thinking 2019, which
Yes.
matches the year of the offense,
Yes.
with some allegations made by the complainant's mother.
Right.
You also referenced a call that the complainant made to Mr. McCarron while he was in custody with MDOC,
Yes.
but you didn't raise that in your summary. So I don't know if that's something, so.
Well, I guess
That would be number 3. Wait, before you
I'm
respond, that
sorry.
would be number 3, the phone call, and number 4, you referenced a transcript that Mr. McCarron had at the motel, and I can't think of the name of it, which is not really relevant, but so the transcript, which you think was seized by the police in that other unrelated matter and might be maybe with the police still. So 3, the phone call, and 4, the transcript.
Yeah, the transcript and possibly other petitions. When my client was going through family court, he had a bunch of petitions and legal documents in a box. Obviously, my client got locked up, so we are making the assumption that the police might have confiscated that. You know, I don't have that information. I'm sure that could be easily resolved by the officer in charge contacting the other officer in charge. And I'm sure if it was confiscated, it would be on evidence. That would take care of that part.
Ms. Johnson, your response.
Thank you, Your Honor. So yes, all of these things were included in Mr. Mihana's requests that he made to me the last time we were there for exam. I don't have a copy of that Kids Talk. I don't have any indication that it was related to this case. It may have been related to their family court case, and so I do not have access to it. I have requested any and all of these CPS reports and any and all of the videos from our contact at the AG's office, and what I received is what I provided to Mr. Mihana. I'm not sure what was, maybe in that hotel room when it was raided. I did ask my officer in charge to connect with the homicide officer in charge to check on those things. I didn't have a chance to check back with her today to see if she was able to find those, but she has not brought anything to my attention, so I don't believe that she has. I just want to note for the record that discovery is ongoing. If we do not have these things, it may not be that I don't have them, but I could find them. I think a written order from the court would be most helpful. Perhaps I could provide that to CPS in the hopes that they could get me more specific things Mr. Mihana is asking for. I would have no objection to the adjournment if I can have time to call off everyone for the exam today. It is 11 a.m., so I should probably have a chance to do that. However, we could also hold it in part because these people have been subpoenaed. They have come down to the courthouse at least once. And it's been a very long with this case.
Ms. Johnson, my concern is if we start an exam at 1 o'clock today, and then any of these items that Mr. Mihana listed and the court recapped appears between testimony taken today and whatever our adjourned date is, we might need to cover the same ground and recall these witnesses. I'm not saying that we can't do it that way. It just doesn't seem the most efficient way to proceed, given that Mr. Mihana, my notes say that on July 8, 2022, he was requesting discovery, and I don't have my detailed notes about what he outlined on that day. But let's address the discovery part first. Mr. Mihana, have you sent a proposed order detailing what you want to Ms. Johnson's office?
I have not, Judge. I have requested. She has worked on some stuff. And then with some other stuff, the answer I got from her, and I'm not taking it personal, I think she's been, great and to work with, is that, well, I don't have it and the officer in charge doesn't have it. So that means
I
I
just
don't
don't want
have
to
it.
sign a generic discovery order
Right.
giving the very
Right.
specific things you requested.
No.
And some of them are things that Mr. McCarron referenced in letters from December of 21. So I don't
Right.
want, okay.
Right. So, and I'm sorry to cut you off, Judge. I wasn't trying to cut you off, but yeah, I'd be more than happy to sit down with my client exactly. Let's see, what he wants exactly, which ones actually make sense. And then I'd be more than happy to present it to Ms. Johnson, and then we can get it signed I think that would be the best route and the easiest route.
How long do you anticipate it would take you to meet with Mr. McCarron, get this list and get an order over to Ms. Johnson?
Well, it probably won't take, because luckily my kids and my wife are up at Mackinac and I was supposed to be up there, but I had the case for today and I have trial on Thursday. So I guess what I'm trying to say is it's easier for me to get around without children and everybody. So it shouldn't take me long. I did see Mr. McCarron last night. So today is the
23rd.
Yeah, I'd be more than happy to see him on Thursday, Judge.
Thursday, the 25th.
Please.
So could you anticipate getting something to Ms. Johnson on the 26th?
Yes.
Or are you looking at more like early next week?
No, because once I meet with my client, all I have to do is type it out. So I'd be more than happy to get something to Ms. Johnson by Friday.
If you get it to her by Friday and give her a couple of days to review it,
Yes.
this court is expecting a discovery order, a proposed order to be submitted by August 30th, which is a week from today,
Okay,
which gives reasonable attorneys time to
sure.
tweak the language and get it over to me.
Okay.
So that's number one. Number two, Ms. Johnson's request to start taking testimony this afternoon, your response?
Judge, I agree with the court in terms of taking partial testimony. I mean, I don't know whether we'll take some, and then my cross-examination is going to be held in abeyance until I get to discovery, so I know what questions to ask. So I think it would be easier for us to just do it all at once we have the outstanding discovery, and that way we can just do it all at once and finish it all at once.
So we would be looking at an adjourned date when, if the discovery order signed on August 30th, and then there's a period of time to produce or fail to produce or be
Yes.
unable to produce. I don't know what the correct
Sure.
terminology would be, but are we looking at maybe the first week of October or sooner?
I think the first week of October would be wonderful for me. Because after
Your Honor, I'm in
that-
a jury trial that week
Okay.
starting on Wednesday, so I could do the Monday or Tuesday of that first week.
I'm sorry, you said you could do the Monday or Tuesday?
Yes, Judge, my trial starts on Wednesday.
What does the third look like for you, Mr. Mihana?
I'm open, Your Honor, on the 3rd.
Monday? I'm saying it out loud and it feels like a bad day and I'm not sure what, no, I'm looking, let's look at October the 3rd. There is nothing scheduled. Mr. McCarron will be the only thing I have scheduled starting at 8:30 or 9 o'clock. Ms. Johnson, do you have a preference?
9 o'clock would be better, Judge, just in case I have anything else in the morning, I can get it done and out of the way. And this is an exam date, correct? Not just an adjourned PCC?
No, it's a live exam date on October 3rd at 9 a.m. It's the only thing that I'm scheduling for that day, so we won't be interrupted. And if Mr. Mihana, on that day, if the discovery issues are outstanding, then I'll entertain whatever motion you want to present. We can't keep adjourning this case. It's been a series of, I'll stop talking. I'll hold the file until I get the order a week from today. October
Yes, please.
3rd, if anything changes between now and then, please reach out to Mary Ann. And I'm looking at Mr. McCarron, who still is sitting in the courtroom. Is there something you needed to say, Mr. McCarron?
Your Honor, I'm just so traumatized by these allegations. It is so unbelievable. I spent 16 months in MDOC because of these allegations, and it's the truth.
No,
There is a order that needs to be get on a SORA from MDOC.
Mr. McCarron, I know that Mr. Mihana would caution you, and you and I have done this before. I don't want you to say anything that could impact you. You and I first met August 13th of last year. I hold on to the file because I know that there are issues that we need to address. Mr. Mihana will do his part by meeting with you on Thursday, getting this order drafted into Ms. Johnson. You will be back here on October 3rd, 9 a.m. We're starting the exam that day. Okay?
I'm fine then, Your Honor. Thank you.
Thank you, Mr. McCarron. Anything else, Ms. Johnson?
No, Your Honor, thank you very much.
Anything else, Mr. Mihana?
No, Your Honor, thank you much for taking us on a short notice. I appreciate it.
No worries. Everyone have a good afternoon. I'll see you on October 3rd.
Thank you, you too. Bye-bye, thanks.
Thank you. I saw Ms. Dornick here for Mr. Fitz.
That's right, Judge.
This is, 22C11369FY. This is State of Michigan versus Cameron Lee Fitz. Thank you, sir. Your appearance, please.
Good morning, Your Honor. Elizabeth Dornick appearing on behalf of the people, P79420.
And sir, your name for the record?
My name is Cameron Lee Fitz-Eel, in proceed.
Thank you. Ms. Dornick and Mr. Fitz, today is the day and time set for the PCC in this matter. The case is scheduled with Judge Brita O'Leary of the 29th District Court. I am Judge Lisa Martin, sitting in the 34th District Court in the city of Romulus. I am substituting for Judge O'Leary purely for this PCC. The further indication in the file is that there is an exam date of August 30th at 11 a.m.
Judge, Mr. Fitz was, I believe, referred for competency. So
I'm just reading the ROA, Ms. Dornick.
All right.
And Mr. Fitz joined early and indicated to this court that he had discharged Christopher Quinn, the defense attorney of record in this matter.
Okay.
So I'm just repeating what he said before you joined us, not speaking to the quality or the veracity of it, just he was here and you weren't yet.
I appreciate that, Judge. Thank you.
Yes, Your Honor, I had him removed on Strickland versus Washington, ineffective assistance of counsel.
Ms. Dornick, from your perspective, is
From
there
my
anything for
perspective,
the
Judge,
court to do this morning?
I would want standby counsel, but you know,
I'm sorry.
I don't think there's anything else to do. I will figure out how to get discovery to the defendant.
Okay, excuse me, Your Honor. May I address the court as well as the prosecutor?
Mr. Fitz, the only thing that this court would caution is that these proceedings are being recorded. They're being streamed live on YouTube, and there's an indication in Judge O'Leary's file that the matter has been referred for competency and criminal responsibility. So there's really nothing for this court to do other than to return the file to Judge O'Leary.
But Your Honor, what I want to address is to the prosecutor. My father is Earl E. Fitz. He passed September 23rd, 2011. You see right here on the lease agreement said Olivia and Earl E. Fitz. That's all state homeowners insurance policy, which the house on Niagara is in my father's name, who's deceased. My brother is Earl E. Fitz also. He's acting like he's my dad. Here's all the evidence. Here's his signature and everything as my dad. Same person made a complaint against me, alleged complaint, on I think the 10th of this month. Earl E. Fitz. He does not reside at that residence. Neither do I. This is my dad. He put that house in my daddy's name, and you see it says Olivia and Earl Fitz. My mother refused to sign it because she knew he was committing fraud with all states.
Mr. Fitz.
Mr. Fitz. Mr. Fitz, the probable cause conference is not the time for you to raise what you believe may be your defenses in this case. It's the time for a plea if a plea is possible or additional scheduling. Inasmuch as Judge O'Leary's notes indicate that the matter has been referred for competency and criminal responsibility reports, this court will, 34th District Court sitting in substitution, will return the file to Judge O'Leary in the 29th District Court until those reports are completed and received by that court for further scheduling and activity, okay?
But as far as my medical needs and everything not being met near y'all, you'll see, you can look at my records, you should see I just beat 3 gun cases in Judge Tracy Green's court. It took 2 years to win that case. And I was out on a personal bond for 2 years. Every time that they asked me for a court appearance, I was there. Never missed one, never. I'm asking y'all, due to my health, I just got out the hospital 3 days before this 10th alleged incident. On June 6th, the house burned down. That's why we on that.
Mr. Fitz.
That's for a personal bond. Yeah.
Attorney Christopher Quinn.
Yes.
Mr. Quinn, Mr. Fitz started today's hearing and has now at least twice indicated to this court that you were discharged.
Oh, I don't even know him. I don't even know this guy.
Mr. Fitz, that wasn't a question to you. That's a question to Attorney Quinn.
Oh, if he's hired another attorney, that's fine. I'm just zooming in at my time.
No.
I don't know this guy. That's the wrong guy. I thought it was the white guy. Pardon me. Excuse me. Yeah, excuse me. That's not the same guy. That was at the arraignment.
Mr. Fitz, Mr. Quinn doesn't have a video up as of yet. So, Mr. Quinn, this court received the ROA from the 29th District Court on the 17th of August. You were still listed as the attorney of record. What this court has just indicated is that we are purely conducting the PCC. There's an outstanding order for criminal responsibility and competency. This court will return the file to the 29th District Court for Judge O'Leary to take additional action as those reports are submitted to that court. Was there anything you wanted to add, Mr. Quinn?
Well, I think it sounds what I just heard a little bit of what Mr. Fitz said. There's a different attorney that would be appointed to him for the arraignment as opposed to the probable cause conference.
Right. I've never seen you in my life.
That's why he's probably saying that. But if he's got a competency report, I would need to see that prior to being able to make a decision on how to proceed.
Right. Your Honor, may I ask Mr. Quinn to please call me so I can explain what's going on with that part of it? I understand the court perhaps doesn't understand all of that because I'm the one that referred him for competency.
Can I have a personal bond?
Ms. Dornick, I'm with you. I understand. Mr. Quinn, do you need to speak to Mr. Fitz this morning? Would that be beneficial?
Yes.
I can. And if Ms. Dornick could also send me a copy of the discovery. I don't know if she has.
I didn't know you were the attorney till now, Judge, or Mr. Quinn, so I'll get it sent.
Okay. Yeah, I can speak with Mr. Fitz.
Okay. Hey, counsel, could you ask for a personal bond for me, please? Because I'm totally disabled. I cannot, they didn't even give me insulin in here. I'm diabetic. I haven't had insulin since I've been here. None of my doctors ordered from doctors.
That's not how I saw that going.
I'll just wait here, Judge.
Judge O'Leary is gonna. Ms. Watt, did you need to speak to the prosecutor in this matter?
I do, and I just wanted to make sure Mr. Morgan is at least in the waiting room, or I spoke to him
regarding this case, so I don't
He's
see him
here,
though.
he's just not
Yeah.
labeled. He's here, right here.
I'm-
move you
Oh,
into-
okay,
I'm
all
here.
right, very, very
here.
good. Yes, I'd like to speak to the prosecutor. Thank you, Your Honor. Uh-oh.
We're back. We're ready.
Oh, okay.
This is 21C7124FY. This is State of Michigan versus Jeffrey Morgan. May I have your appearances, please?
Good morning, Your Honor. Maria Murad on behalf of the people, P80605.
And good morning, Your Honor. Coral Watt, appearing on behalf of Mr. Morgan, P41508.
Mr. Morgan, state your name for the record, please, sir.
Jeffrey Morgan.
Thank you. Today is the day and time set for the PCC in this matter. Ms. Watt, I explained before you came on that I am substituting for Judge O'Leary purely for this PCC. The attorneys have had the opportunity to speak. How are we proceeding this morning?
Your Honor, the prosecutor has indicated that she emailed me the discovery this today. So my client, I've had an opportunity to speak with my client, and he is demanding his preliminary examination.
The court did not send, the 29th District Court did not send the dates over. So I will write on the ROA that the exam has been demanded, and that court will schedule the exam with you and the prosecutor.
No worries, sure.
Thank you, Your Honor.
Was there anything else on behalf of the people?
Nothing further, Your Honor.
Anything else on behalf of the defendant?
Nothing further, Your Honor. Thank you.
Thank you so much.
Thank
Have
you.
a good day, Mr. Morgan. Have a good day,
Have a good
sir.
day, Your Honor.
This is the recall of 22C11369FY, State of Michigan versus Cameron Fitz.
Elizabeth Zornick on behalf of the people.
Christopher Quinn on behalf of Mr. Fitz, P69483. Mr. Fitz is appearing via Zoom today.
Mr. Quinn, let me apologize to you. When Mr. Fitz came on and indicated that you had been discharged, and I repeated it to Ms. Dornick, I was not aware of the fact that there had not been communication and a formal discharge or discontinuation of your service in this matter. That being said, the case was scheduled this morning for PCC. There is the referral for competency and criminal responsibility outstanding. Mr. Quinn, how are we proceeding this morning?
Well, I would like to schedule for another PCC so that I can get discovery and sit down with Mr. Fitz. And then I also would like to address bond.
the bond appears to be 10,000, 10% at this time. Mr. Quinn, did you discuss that with Ms. Dornick?
No, I have not.
Okay, what is your request regarding bond, sir?
I would ask for a personal bond, and primarily because Mr. Fitz suffers from a number of medical issues, diabetes, and other ailments that are require more extensive medical attention than what he's receiving currently in the Wayne County Jail. I believe that Mr. Fitz, because of that, is in need of doctor's attention, and therefore should be given a personal bond with tether.
Your Honor, in brief response.
Yes, ma'am.
The defendant is charged as a habitual fourth offender. And as you can see on the information, the defendant has numerous convictions, more than a habitual fourth, including a number of larcenies over the course of his life. The victim in this case is, or complainant in this case, is the defendant's brother, Mr. Earl Fitz, who is 68 years old. He resides in a home currently in Wayne. They previously lived, I believe, in Inkster, and that house did burn down earlier this summer. And there is some rift about that, as the court heard earlier. But as far as bond is concerned, for a protection standpoint, the people specifically request no contact with the complainant, no contact with the house on Niagara in Wayne, and if the defendant would like to go back to that home to collect belongings, he would have to have police escort. He's sitting here shaking his head, so I'm sure he doesn't agree with the people's position.
Yes.
But that is the people's position. I think the bond, 10,000, 10% is appropriate given his criminal history. I understand he has physical disabilities. That didn't stop him from assaulting his brother. So
Alleged.
Thank you, Judge.
Anything else, Mr. Quinn?
No, Judge.
Thank you. The defendant's request to modify the bond is denied in its entirety. The file will be returned to the 29th District Court for additional scheduling as is necessary upon receipt of the report from the Forensic Center. Anything else on behalf of the people?
Judge, initially you said 8:30. So I just want to clarify, do we have a date, or will 29th District Court just send us another date?
Ms. Dornick, the ROA that came over to this court indicates PCC today at 11 and exam August 30th at 11 a.m. Was that the information you also had?
That is all I had, yes.
So the dates that they're scheduled, I'm not changing.
I understand.
I can't imagine with the outstanding issues.
Exactly. Okay, thank you so much. I appreciate that, Your Honor.
Thank you.
Can I talk to
There's
counsel?
an exam scheduled for August 30th at the 29th District Court.
At 11 a.m., yes, sir.
Okay.
Can I talk to counsel? I need to, so I can get out of here.
Yeah, I'll come in and see you. I need to get the discovery. I'll be in there.
Today?
Not today. But
I need to talk to you alone on this right quick. I need you to do a couple things for me, sir.
Yep, I'll come and see you.
I can't talk to you right now.
That concludes this matter. Mr. Fitz, he's already indicated that he'll come see you. Thank you, Wayne County. Have a good day.
Thank you, Your Honor. All the best to you and your staff.
You too, sir. Good morning, Ms. Dennis.
Good morning. How you doing, Your Honor?
I'm well. How are you, ma'am?
Well, down a staff member, but making the best of it.
What are you here for this morning?
I was here on the date of Fitz and the date for Morgan.
Morgan, the 29th will have to set the date. They Ms. Watt appeared and they're demanding an exam. And then Fitz already has a date of August 30th at 11 a.m. But you heard the conversation. And
yes, so Morgan, I
think
just
I
have
muddied
to.
it up.
Yeah. Morgan, I just have to wait, but it will be in Wayne.
Yes, ma'am. We were just for today's PCCs.
Oh, okay, because the judges are out.
Correct.
Okay, so I'll look it up from Wayne at a later time. Great.
Thank you, ma'am.
That was all I was here for, Your Honor. Good to see you.
Good to see you as well. Have a good afternoon.
You too. Take care.
Bye-bye. Andy, did you have something else pending? Oh.
Good afternoon, Van Buren.
Hello.
We are just waiting for our MIDC attorney to hop into the meeting, and as soon as she is here, I will get your defendant in a breakout room to speak with her prior to arraignment.
Sounds perfect. Thank you.
You are welcome.
We'll get that done. You can talk to them and then we'll do your arraignment. We get you out of here. It's above my pay grade, but we'll see what we can do.
All right, Van Buren, Attorney Medina is present, so I'm going to go ahead and put you into a breakout room.
Sounds good.
Thank you. I just put up my volume. Thank you.
You are welcome.
You can sit there and talk or whatever you need.
Ms. Medina?
Yes, Your Honor.
This is 220600FY. This is State of Michigan versus Daniel O'Neill Adams. May I have your appearances, please?
Yes, Your Honor. Crystal Marie Medina on behalf of Mr. Adams.
Mr. Adams, state your name for me, please, sir.
Daniel Adams.
Thank you. Today is the day and time set for your arraignment in this felony matter. You've had the opportunity to speak to Ms. Medina.
Yes, ma'am.
Ma'am, how are we proceeding this morning?
Your Honor, with regard to the arraignment, we would waive formal reading and stand mute, Your Honor.
Thank you. Mr. Adams, inasmuch as this is a felony matter, you have a right to be represented by an attorney. If you're unable to afford an attorney through your own resources or that of family and friends, the court may appoint one for you. There is a petition for a court-appointed attorney attached to the front of the file. The court has signed that. You will be assigned an attorney going forward. It will not be Ms. Medina. The attorney assigned to you will use the phone number you've provided on your forms this morning and the email address to be in communication with you. Sir, you also have the right to be considered for pretrial release. There is a bond recommendation from Van Buren Township Public Safety Department that your bond be set at 10% based on the fact that you have outstanding warrants. You have 12 pending warrants out of Detroit, Retford, and Dundee courts. You have a history of non-appearance. The Public Safety Department is also requesting that if you are able to post a 10%, that you be placed on GPS tether. Ms. Medina, what say you as to this recommendation?
Your Honor, I would say that the department's, I guess the Public Safety Commission, the department's concerns with regards to these pending cases and Mr. Adams' alleged non-appearance would be addressed with the GPS tether, Your Honor. I'm not sure why a monetary bond would be required in this case. While I do understand they are serious allegations, Your Honor, it is one low-level felony, what is considered lower level, a misdemeanor. They're both non-assaultive in nature, Your Honor. And so the concern seems to be simply these outstanding matters, which from my understanding involve not being able to comply with payment plans or confusion as to follow-up dates on these traffic issues, Your Honor. My client indicated employed through a temp service, Your Honor. So he does have employment that he needs to get back to, but not secure enough employment that would not cause concern for me as to whether he would in fact be able to post $1,000 bond or not. Mr. Adams' indication was that he's not sure if he would be able to post that bond. My understanding is that Mr. Adams suffers from asthma, which is a concern with regards to his continued incarceration, given the ongoing pandemic. He understands that he has to come to court, Your Honor, and he looks forward to doing that and clarifying the situation.
Thank you, ma'am. The court will deviate from the recommendation, set Mr. Adams' bond at $5,000, 10%. The court will not impose a GPS tether at this time. The next step in these proceedings, Mr. Adams, is that you will return for a probable cause conference on Wednesday, August 31st, 2022 at 8:30 a.m. That's back here with me in Zoom courtroom number 1. Again, just so we're clear, this case number is 220600FY. Next appearance date is August 31st, 2022, 8:30 a.m. Anything else in this case, Ms. Medina?
No, Your Honor, thank you so much for your consideration.
Thank you. And Ms. Medina, thank you for jumping back on for this late arraignment. Mr. Adams, good luck to you, sir. I will see you back here on August 31st, sir. Have a good day.
I appreciate it.
Take care, Mr.
Thank you.
Adams, and it's my pleasure, Your Honor. Thank you.
Thank you, Van Buren.
Have a good day, Your Honor.
You too, sir. Thank you.
Hang on just a second.